Good morning, everyone. Good morning, Taran. And I am back with a list of the current legal issues that we have to take up this week. And the first issue that we are taking up this week on Monday is EWS quota and evaluation in the light of NEET PG case. A very recent controversy which was which perpetrated through the reservation policy, this EWS quota. You must be knowing about the EWS quota, the economically weaker sections, and the Constitution 103rd Amendment Act 2019 has accorded this EWS category on the general category. Okay, this 10% to the economically weaker sections. If you remember that the Mandal Commission, which was the second backward classes commission, which was constituted by the Morarji Desai government and under the chairmanship of BP Mandal, and which popularly came to be known as Mandal Commission, was tasked with the job of studying the economically and socially backward classes in the country. Okay, deciphering and determining or ascertaining the socially and educationally backward classes in the country. Okay. So the second backward classes commission, or the Mandal Commission, came out with lots of suggestions and recommendations, one of which was giving 10% reservation to the economically weaker sections amongst the general category. It suggested that out of 50%, because 50% is a slab which is created by the Constitution under Article 15 and 16, and therefore within 50%, remaining within the contours of 50%, 27% should be given to the OBCs, while 23% should be given to the SCs and STs. And in addition to this, 10% should also be given to the economically weaker sections amongst the general category. But every recommendation and suggestion was considered by the government except this one, EWS quota. So this EWS quota was given a constitutional status, and this was recently given heed by the present government, giving 10% reservation to the economically weaker sections amongst the general category. Now there was yet another policy within this policy of EWS quota, that certain seats were to be reserved in the NEET PG courses, National Eligibility Entrance Test. If you know this, what is NEET? NEET is a common medical examination now, like CLAT. Okay. And almost all the medical colleges in the country, including that of central universities, have combined their their exam, okay, their admissions within the NEET. Okay, recently AMU was for some time out of the NEET, but now AMU JNMC also has come under it. AIMS has also come under it. Okay, now what is the issue? The application of reservation for OBCs and EWS in the all India quota seats for NEET PG was recently challenged in the case of Neil, Aurelio, Nunes and others versus Union of India and others. The challenge was twofold. Firstly, it was contended that the introduction of the quotas after issuance of notification of the examination is not appropriate, and it amounts to changing rules in the middle of the game. So after the notification was issued for the NEET PG, so after that, after it was issued, then the introduction of the quotas was made. So it was said that it is not appropriate. It should have been prior to the issue. It should have been done prior to the issuance of the notice. And this amounts to changing the rules in the middle of the game, which is uncalled for. Secondly, it was argued that the criteria decided for qualifying as EWS to be a beneficiary of the quota is arbitrary and over-inclusive. The Supreme Court of India allowed the introduction of both the quotas for this academic year to expedite the admission process. However, the fate of EWS reservations as far as admissions in the subsequent academic years are considered remains undecided as of now. Okay. The Supreme Court of India allowed the introduction of both the quotas for this academic year to expedite the admission process. Expedite the admission process. Okay. The Supreme Court said that, we have to allow this quota, okay, for this academic year, because in order to expedite the admission process. Okay. However, the fate of EWS reservations as far as admissions in the subsequent academic years are considered remains undecided as of now. The genesis of the EWS quota lies in the 103rd Constitutional Amendment Act. The only challenge which can be used to question the constitutionality of the amendment is the basic structure doctrine. To analyze whether EWS quota goes against the basic structure of the Constitution, it is necessary to first understand what the basic structure doctrine is. You all know this, that this was propounded in Kesav Nanda Bharti versus the state of Kerala. Back in 1970, 24th, 25th and 29th constitutional amendments were challenged in the landmark case of Kesav Nanda Bharti versus the state of Kerala. Among the amendments challenged, only a part of the 25th Amendment which restricted judicial review was struck down because it violated the basic structure of the Constitution. Thus, the phrase basic structure is used to denote certain principles embodied in the Constitution which are to be kept sacrosanct to preserve the essence of the Constitution. Hence, the question which comes to our mind is whether the EWS quota modifies the Constitution to such an extent to violate its basic structure. Because basic structure doctrine was like the other way out for the Supreme Court, because the Supreme Court devised this doctrine after a long battle between the judiciary and the executive over the power of the judicial review to be applicable on certain constitutional amendments. Okay, and finally the Supreme Court said that if we are going to keep the constitutional amendments again and again within the purview of judicial review, the parliament will keep on bringing some legislations to keep it out of the purview of judicial review, and hence will continue to nullify our judgments. So it is better to devise or propound a theory which is vague and undefined, and will be its definition and the contours of such doctrine will be completely will be our prerogative. Okay, no one else will be able to understand what this doctrine is. Okay, so basic structure doctrine was finally devised. So basic structure doctrine is what the judges say it is. Okay, what is the definition of basic structure doctrine? Basic structure is what the judges say it is. If the judges of the Supreme Court says that independence of judiciary is basic structure, then it is the basic structure. If EWS quota happens, for example, to violate the basic structure of the Constitution, then it definitely violates. There is no doubt about it, because the judges say it violates. So, we have come across a doctrine which is literally vague and undefined, and we are now to decide as to how far the EWS quota modifies or violates or falls in consonance or in contradiction of the basic structure of the Constitution. Okay, even though the above mentioned did not discuss the constitutionality of the EWS quota, it is important to analyze the pertinent grounds on which the 103rd Amendment might be challenged for violating the basic structure of the Constitution. In this context, the first question which the author intends to analyze in this blog is whether the 50% ceiling on reservations is binding, and hence is the EWS quota appropriate in light of the existing jurisprudence on the highly contentious subject of reservations. Because the issue or subject of reservation is already very contentious. Contentious in the sense because already there are so many petitions which are pending and list pendants before the Supreme Court, challenging the continuance of the reservation policy even after 72 years of the enforcement of the Constitution, because we have traversed and treaded on a very long journey, and we have come a long way in improving the conditions of these scheduled castes and scheduled tribes and OBCs in our country. There was a time back at the time with the commencement of the Constitution in 1950 when the things were really not good, but now things have changed. They have come at par in the status and inequality and of opportunity. Now, since we have created a social equality in the society through these reservations, the reservation should not continue. Okay, there is an already existing contentious issue which is prevailing in the country, reservation. And for example, it now releases yet it's another offshoot, which is the EWS quota. And then in the NEET PG case, it happens to secure seats for the EWS people. Okay. Now, the second question which the author would analyze is whether reservation based on solely economic criteria is appropriate or not. Lastly, the author would analyze whether the class of individuals carved out by the amendment suffers from over-inclusion or not. See, now the question is, can economic condition be the criteria for granting reservation? Because Constitution never recognized this economic basis as one of the criteria for granting reservation. What do the articles 15 and 16 say? They talk about social and educational backwardness. They don't talk about economic backwardness. They talk about social and social and educational backwardness. Okay, any caste or community which is socially and educationally backward. Okay, economic conditions are something which are subject to change from time to time. A community or a class or a family might be doing financially well and financially good in some time, while there may be recessions, there may be economic downturns during the cycle of one's life. But so economic backwardness is not permanent. It remains over a period of time and it goes away. Okay, so social and educational backwardness is something which is a stigma in the society. So the Constitution recognized social and educational backwardness as one of the criteria for granting reservation. So the question which was supposed to be mooted by the Supreme Court in this case was whether the economic criteria is appropriate for granting reservations or not. Now, is the 50% ceiling on reservations binding? Now, currently 49.5% of seats are reserved based on caste, like 27% for OBCs, 15% for SCs, 7.5% reservation for STs. Now, I have already told you in the beginning of the lecture what is the criteria right now. After the EWS quota, which provides for 10%, the percentage has gone up to 59.5%. The question is, which arises now, as if the 50% limit placed on reservations is at all binding or not. Because if you go back to 1992 and peruse the observations of the Supreme Court in Indra Swahani versus Union of India, which is popularly known as the Mandal Commission case, the Supreme Court categorically emphasized that 50% ceiling shouldn't be violated except in exceptional circumstances. Okay, in extraordinary circumstances. But the question is whether granting the economically weaker sections extra 10% of reservations, which will break the ceiling of 50% and go at the figure of 59.5%. Is this an extraordinary circumstance which would fall to be which will go to be excused or not? Okay, so Ayush is commenting it. I know it's a very bold statement to make, but don't you think the very identification of humans with caste, religion, etc. is something which lies at the root of all evils we see today? Obviously, Ayush, that is the root of all evils in the society. There's no doubt about it. But still, that reality cannot be neglected or ignored. Okay, people belonging to the STs and OBCs have faced cruelty and utter torture since ancient times in our society. and their conditions, their social and educational conditions were supposed to be improved anyhow. So this was a reality which was not supposed to be neglected or avoided, and hence I really believe that reservation has really helped a lot. But still continuing with the reservation policy might be a problematic thing for me now, because right now we should not continue to recognize people with their caste and religions. We should continue to recognize people as a whole, as a one humane society. That's all right about it. But let us now come into the practical legal field. Okay, this is a humane statement that you have made, and it's really worth appreciating. But still, I would say that let us face the reality now, and let us decide the case according to the legal facts. Okay. The 50% ceiling on reservations was introduced in the case of M.R. Balaji and others versus the state of Mysore. What is to be noted here is the system of reservation was treated to be an exception of the right to equality as enshrined in the constitution, which is different from the approach of the SC in later cases. In M.R. Balaji, the SC seemed to follow the vision of formal equality, which essentially entails providing the same treatment to everyone, regardless of the inherent differences, such as the perpetual discrimination and consequent disadvantageous position of individuals due to the existence of a stringent caste system. Okay, exactly what you commented, Ayush, what has been said already been said in this article. Okay. Now, what was special about the M.R. Balaji case? That the Supreme Court followed a vision of formal equality, like no division, no differences, okay, no discrimination, especially based on stringent caste system. However, 13 years later, the SC recognized substantive equality in the case of a state of Kerala and another versus N.M. Thomas. In this case, the SC interpreted reservations as being an element of the right to equality and not an exception to it. Here we see a shift in the SC's interpretation of equality from a formal to a substantive one, taking into account the inherent institutional and structural disadvantages experienced by individuals. Now you see that the the reservation is already a part of equality. How? You must have read about reasonable classification based on intelligible differentia under Article 14 of the Constitution. You all must have read about it. Okay. What does Article 14 says? The state shall not deny to any person equality before law or the equal protection of laws. Right? Equality before law means that everybody is equal before law. There is rule of law. A.V. Dicey's rule of law. That's it. Everybody is equal before law. But the phrase equal protection of laws is not that simple. Equal protection of laws simply means that society can be divided or classified reasonably into different groups, and such differentiation or categorization has to be based on intelligible differentia with a purpose. Okay, you should not classify the society reasonably without a purpose. There must be a purpose to be achieved, and the purpose to be achieved must have a connection with the classification, right? Must have a connection with the classification. What kind of classification? What kind of intelligible differentia? That you have a purpose. For example, if you are making a law, the law must intend to achieve something for a particular class of people within the society. And if that class is different from the other people in certain circumstances or in certain features or characteristics, then definitely that is protected within the equal protection of laws. The best example is that of reservation. SCs, STs and OBCs are reasonably classified communities within the whole community based on intelligible differentia, because their educational and social status was not that good as that of the general category. So it was necessary and pertinent for the government to do something for them. So the reservation policy was protected within Article 14 as within the phrase or under the shadow of equal protection of laws. dividing the society into different categories based on intelligible differentiation and doing something special for them. Okay, and there was no comparison between the general category and these reserved classes, because if the classes were to be discriminated amongst themselves, then there was supposed to be the violation of equality. Now you cannot contend the violation of equality between as a discrimination between a general category and between a reserved classes. Okay, so here was a shift in state of Kerala and another versus NM Thomas. Here was a shift from the formal interpretation of reservation to a substantive one, now taking into account the inherent institutional and structural disadvantages experienced by individuals. Exactly, I used what I said to you, that the Supreme Court earlier in MR Balaji case held exactly what you said in your statement. But in yet subsequent case of state of Kerala and another versus NM Thomas, the Supreme Court was not able to ignore the reality, and hence there was a shift from a formal to a substantive one. Okay, so please now tell me if you have understood the discussion up till here. Have you understood, or do you still need to ask something? Understood. Okay, good. There are intelligent students out there. I really appreciate. Okay. So it was in Indra Swahani versus Union of India. Very famous case. Popularly known as Mandal Commission case, 1992. Which complicated the stance of the Supreme Court as far as interpretation of equality is concerned. The SC did recognize substantive equality by reaffirming the NM Thomas, but at the same time retained the 50% ceiling on reservations, barring certain exceptional circumstances. Gautam Bhatia, Delhi-based lawyer, argues that this stand of Supreme Court is not tenable, considering the fact that substantive equality depends on the level of disparity or disadvantage present in the society. It cannot be limited by a certain decided percentage, 50% in this case, if inequality persists and requires a greater level of affirmative action. Okay, greater level of affirmative action. Now this Ananya, which part are you talking about? Which part you want me to repeat? This is a very lengthy discussion. You have to stay with me for this whole 1 hour. Indra Swahani versus Union of India. I am saying, Ananya, listen to me very carefully now. Very famously known as Mandal Commission case from 1992. Now this complicated the stance of the Supreme Court as far as the interpretation of equality is concerned. The Supreme Court did recognize substantive equality by reaffirming the NM Thomas, but at the same time retained the 50% ceiling on reservations, barring certain exceptional circumstances. Gautam Bhatia argues that this stand of Supreme Court is not tenable, considering the fact that substantive equality depends on the level of disparity or disadvantage present in society. It cannot be limited by a certain decided percentage if inequality persists and requires a greater level of affirmative action. Gautam Bhatia is trying to say that if you are recognizing substantive equality, you are recognizing the fact that there are disparities and disadvantaged people in the society, or there are communities who live in disadvantageous positions, right? Now, when there are so many disadvantaged communities, living in the society facing so many disparities and discriminations, how can you decide a percentage for them? 50% in this case, you cannot fix a percentage. There are all communities out there. We have to work for their upliftment in general. We cannot fix a 50% criteria for them. Okay. Now this requires a greater level of affirmative action. This substantive equality cannot be limited by a decided percentage of reservation. Okay. In the author's opinion, the 50% ceiling limit on reservations is an attempt by the judiciary to give priority to both formal and substantive equality. However, if there are compelling reasons behind providing reservations to a particular group of individuals, the 50% limit should not act as a restriction. The 50% ceiling, after all, has been created by the judiciary and cannot be used to restrict the constitutional mandate of equality of opportunity. When we talk about equality of opportunity, can we restrict this equality within the percentage, within the contours of a given percentage? This 50% ceiling limit of a reservation is limiting the scope of substantive equality. Okay. You want to bring a calculated number of people within the privileged class. You are trying to leave the rest of the people behind. That is what Gautam Bhatia is asking. Do not limit the percentage. Okay, do not limit the percentage. Limiting would limit the upliftment policy. Okay, the doctrine of substantive equality. The 50% ceiling, after all, has been created by the judiciary and cannot be used to restrict the constitutional mandate of equality of opportunity. However, whether there are any such compelling reasons behind the introduction of the EWS quota have to be examined through the next two sections. Firstly, whether it is appropriate to introduce reservations solely based on the economic criteria, and secondly, whether the class of individuals carved out by the amendment suffers from over exclusion or not. Okay, is reservation solely based on economic criteria appropriate? Now, this is the most important question in the whole article. Because the constitution did not recognize, the constitution makers did not put economic backwardness as one of the criteria for giving reservations. Okay, they recognize social and educational backwardness. They did not see economic backwardness as something to be a ground for giving reservations, because economic backwardness, I have told you, is a temporary phase in everybody's life. People, money comes and goes. It happens with everyone. There is a phase of life in most of the people's. With most of the people, there is a phase of life when everybody has to struggle for money, and there comes a time when everybody becomes financially well. So economic backwardness cannot be a criteria, but social and educational backwardness can be, because people, SCs, STs and OBCs have been facing social and educational torture. They have been like prohibited from enjoying certain social and educational privileges in the society. Okay. And once a community grows socially and educationally, it will automatically become economically well or financially well. Right? So, now considering this question of law, if reservation solely based on economic criteria is appropriate, since reservations are aimed at undoing the long history of discrimination and exclusion meted out to certain groups of individuals, caste has been seen as one of the most important parameters for reservations. However, there is nothing wrong with introducing reservations solely based on economic criteria. In fact, in the case of Ashok Kumar Thakur versus Union of India, the SC said that caste does not necessarily have to be the only criteria for identifying backwardness. Okay. The Indian judiciary has not been averse to the idea of economic reservations. In the case of KC Vasant Kumar versus the state of Karnataka, Ayush is asking, what about the concept of OBC creamy layer? Why the economic criteria comes into play there? See, the economic criteria comes within the OBC community. There is not a problem. There is not a problem because, see, Ayush, the case with OBCs is a little bit different with the case of SCs and STs. OBCs were recognized as socially and educationally backward communities, and people out within the OBCs who were financially well were not given reservations, and they were carved out to be the creamy layer within the reservation policy. But you see, the whole reservation policies of the OBCs is based on the criteria of social and educational backwardness and not the economic criteria. Okay. People with a good financial income have been carved out and have been categorized as creamy layer within the OBC community, because people with money will be able to enjoy privileges in the society, and there can be, they can have access to certain educational institutions also. Okay, so that is a criteria within the criteria of social and educational backwardness. That is not a sole criterion on which the whole reservation policy is based. Okay, there is a clear division created on the basis of economic criteria amongst OBCs. Yes, exactly, that's right. But I am saying that economic criteria exist within the contours of social and economic backwardness criteria. It is not a criteria which is isolated or different from the rest of the criteria. It is a criteria within the contours of the social and educational criteria. Okay. But exactly, Muhammad Riaz, but it cannot be the only criteria. And that's what we are discussing, that economic backwardness cannot be the only criteria. Okay. Yes, Ayush. See, why it does not apply to SCs and STs? Why it does not apply to SCs and STs? Because scheduled castes and scheduled tribes, they were in toto socially, educationally, economically backward. Same was not the case with OBCs. Like the whole SC community, the whole ST community, like 100% of them, they were socially and educationally backward. They were treated as untouchables. Their condition in the society was beyond imagination. So their reservation is not limited by anything. Okay. Even if they are economically well, still they are to be treated as untouchables in the society. So what they need to grow on which grounds? They need to grow on social and educational grounds, right? Same was not the case with OBCs, or similar was not the case with the OBCs. The OBCs had to face social and educational backwardness, simple. And some of them were economically well or financially well, so they were carved out to be the creamy layer. Okay. And then some of them were provided social and reservations on social and educational backwardness criteria. Okay. People belonging to OBCs, Muhammad Riaz, have advanced substantively, and legislators felt the need to lower the privileges accordingly by further dividing them. Exactly, that is the case. That is the case. Okay. So the Indian judiciary has not been averse to the idea of economic reservations. The Indian judiciary has never been against this policy. In the case of KC Vasant Kumar versus the state of Karnataka, Justice D.Y. Chandrachud gave two tests to determine if a certain class of citizens can be considered backward or not. Very important. See, listen, now read the document and listen to me very carefully. Firstly, the class of citizens in question should be comparable to members of the SCs and STs in terms of their backwardness. Secondly, they should satisfy the means test to determine economic backwardness as decided by the state government, taking into account the economic condition prevailing in the society. Okay. Justice D.Y. Chandrachud has given two tests to determine whether a class of citizens can be considered backward or not. Firstly, the class of citizens in question should be comparable to the members of the SCs and STs in terms of their backwardness. Like when we are talking about EWS or we are talking about OBCs, their condition, like we are alleging them to be backward, so their condition or their backwardness should be comparable to the SCs and STs, like exactly like their condition, their status is exactly like that of the SCs and STs. And if it is comparable, then it must be classified as a class eligible for getting reservations. Secondly, they should satisfy the means test. Like for example, there should be a test to determine economic backwardness. There should be a criteria set by the state government that people earning below this level or people earning above this level, okay, like for example, people earning below 8 lakhs per annum, that's a central government criteria, however, but still, as decided by the state government, taking into account the economic condition prevailing in the society. Like as per the economic condition prevailing in the society, the state government can determine a slab or a ceiling. Like people earning below that slab or a ceiling can be classified as economically backward. So there is a means test. How far people are able to earn annually, right? So this was the two-pronged test given by Justice D.Y. Chandrachud in K.C. Vasant Kumar versus the state of Karnataka. Justice Desai in the same judgment opined that the only criterion that can be realistically devised is the one of the economic backwardness. He warned that using caste as the only parameter for measuring backwardness would lead to an inadvertent perpetuation of the caste system. He further focused on the point that caste is a concept rooted in Hinduism. See, Ayush, the point you were trying to make has been elaborately emancipated by Justice Desai. He further focused on the point that caste is a concept rooted in Hinduism and is unknown to other religions. In the author's opinion, Justice Desai's conclusion about economic criteria being the only realistic parameter is to some extent extreme. However, it can be safely concluded that the idea of introducing reservations solely based on economic criteria is not repugnant to the existing laws. Okay? Is not repugnant to the existing laws. Does the class of individuals carved out by the amendment suffer from over-inclusion? Why Justice Desai recognized economic backwardness as one of the criteria? Because he found it better than the reservations based on caste system. Okay? Because he says that reservations based on caste system, they inadvertently perpetuate the caste system, which is an evil and stigma on our society. This is a concept rooted in Hinduism and is unknown to other religions. So he preferred economic criteria over the criteria based on caste. Okay, and he said that idea of introducing reservations solely based on economic criteria is not repugnant to the existing laws. Okay. Does the class of individuals carved out by the amendment suffer from over-inclusion? Like people have been over-included. What do you think? Because there's a factual problem which we are facing here. What is the factual problem? There's a class of individuals which has been deliberately and inadvertently brought within the category of reserved class. Don't you think this has led to over-inclusion? Okay. As far as the concept of equality is concerned, equal treatment must be provided to those who are similarly placed. To identify such similar groups, the state has to draw parameters that are justifiable. It is the responsibility of the state to prevent under-inclusion or over-inclusion in such groups. Ayush, don't be sorry. This is just a discussion. Don't be sorry for anything. You are presenting your views, and I am glad students are participating so vehemently and vigorously in the class. And this is really worth appreciating. You don't have to be sorry, and no one else needs to be sorry for anything. You are just putting your points and views across, and that's really appreciable. See, you cannot see a concrete argument that would make the case for SCs and STs and special treatment meted out to them in the lines of economic criteria. But Ayush, I would ask you to, go through the conditions prevailing in the ancient Vedic society. We have come down to the present day living with that mental state that Shudras in our society are supposed to be ill-treated. And it was therefore pertinent for the state. It was therefore pertinent for the state to, do something for their social and educational upliftment. They were not given jobs. They had to face a lot of torture. They were not admitted to the educational institutions. Okay, they were socially deprived. Okay, they were given places with stink and squalor and stench of the drains all around. Okay, and stinking slums to dwell into. Okay, now these were the conditions which were prevailing and which have been prevailing since the ancient times. And unfortunately, we have come down to the present day, even in the 21st century, where people out there in the rural India still practice untouchability. So their social and educational upliftment was absolutely necessary. Okay, it was necessary. It was important to make them lawyers. It was important to make them doctors, engineers, IAS officers, IPS officers. They were required in every walk of life so that their community may grow socially and educationally. Right? Have you understood this? Economic criteria is accorded to a class within the general category who may be said socially and educationally backward, but due to some other circumstances, owing to some other circumstances, they are economically backward. Okay, so the two cases are absolutely different. The two cases are absolutely different here. Okay, does the class of individuals, now whether this leads to over-inclusion, to identify such similar groups, the state has to draw parameters that are justifiable. It is the responsibility of the state to prevent under-inclusion or over-inclusion in such groups. One of the major grounds of criticisms of the EWS quota introduced by the 103rd Constitutional Amendment is that the criteria set for getting the benefit of the newly introduced reservation are over-inclusive. Now, the author of this article is trying to contend that this is an over-inclusive policy which has come in the shape and form of 103rd Constitutional Amendment Act. Because it is unnecessarily trying to include these economically weaker sections from the general category. And this would render nothing. Okay. Who in fact are not in need of such a scheme would be in fact included in this. Okay, the principle of equality mandates treating equals equally, and hence it is the responsibility of the state to carve out subgroups of individuals which are homogeneous in terms of the level of backwardness. If an overwhelming majority of society is eligible to take benefit of the reservation scheme, then again the individuals who are comparatively well off would be in a much better position to take advantage of the reservation and further better their position, while the individuals who are in need of the scheme do not benefit to the desired extent. In the case of Ram Singh versus Union of India 2, The Supreme Court has emphasized the fact that while introducing new criteria for reservations, the state has to ensure that it reaches the most deserving class. You know, in Ram Singh versus Union of India, the Supreme Court said that if you are introducing a new criteria for reservations, then the state must satisfy itself and the people out there that through this criteria it is reaching the most deserving class. Now, by introducing the EWS category, do you think the states has itself or has it let the country satisfied on the ground that it is reaching the most deserving class? The reservation is reaching the most deserving class. Okay. There are complaints from Ayush and Damini that the stream is lagging. The stream lags with 20 or to 25 seconds behind. That is unavoidable. It will happen. Okay. Don't worry. The beneficiaries of the 10% EWS quota include those who have a family with gross annual income below rupees 8 lakh. You know, the same economic slab has been applied here, which is applied to the creamy layer amongst the OBCs. Okay. So, जिनकी 8 लाख एनुअली सालाना इनकम से नीचे है, वो 10% EWS कोटा में इंक्लूडेड है. Income shall also include income from all sources, that is salary, agriculture, business, profession, etc. for the financial year prior to the year of application. Also, persons whose family owns or possesses any of the following assets shall be excluded from being identified as EWS irrespective of the family income. Okay, 5 acres of agricultural land and above. Okay, like even if they are not earning 8 lakhs annually, then 5 acres, if they have 5 acres of agricultural land and above, that means they are like big people, big guns. Residential at 1000 square feet and above, residential plot of 100 square yards and above in notified municipalities, residential plot of 200 square yards and above in areas other than the notified municipalities. So if people who are not even earning 8 lakhs rupees per annum, or are earning less than 8 lakh rupees per annum, but still they own either 5 acres of land or above, or residential place of 1000 square feet and above in an urban area, a residential plot of 100 square yards and above in notified municipalities, residential plot of 200 square yards and above in areas other than the notified municipalities, they are not going to be eligible or a beneficiary in the 10% EWS quota. Okay. Okay, right. According to an economic survey conducted in 2015, around 7.7 crore families reported an annual income of less than rupees 6 lakh. And do you know, I'm sorry, that that it's very easy in India to get your EWS certificates even though you are earning more than 8 lakh rupees per annum. You might be owning more than 5 acres of agricultural land, but still you possess an EWS certificate. People out there are getting it, you know. This happens so easily in India. मैं क्या बताऊं आपसे? This is a big problem. That there are no checks and mechanisms to check these kinds of frauds in India. Now, more than 7.7 crore families in India, they reported an annual income of less than rupees 6 lakhs. However, rupees 8 lakhs per annum has been decided as the income ceiling limit for being eligible to receive the benefit of the 10% EWS reservation introduced by the 103rd Constitutional Amendment Act. Okay. Certain surveys have indicated that an overwhelming majority of Indian households, like 99% approximately, fall under the EWS category as per this income ceiling limit. Like every Indian household is falling within this category. Every other person is holding an EWS certificate now. So what do you think? There is a fight within the 10% now. Now it further reveals that around 97.93% of upper caste households too are eligible to be beneficiaries of the EWS quota. Ayush is asking how. You don't know, you don't have an idea how this goes on in India? Let us not discuss how it goes. There is something called jugaad. The income limit of rupees 8 lakhs is much higher than the income limit fixed for demarcating population living below poverty line, BPL. It might be argued that reservations are not poverty alleviation programs, and hence the criteria for demarcating the beneficiaries of the EWS quota in this particular context can very well be different from the criteria which are used to demarcate population living below the BPL. So that's what I am telling you. There should be a mechanism within the law or through the law, created by the law, to check that people do not indulge in fraud. And they should not get their fake EWS certificates made, because it has become very easy nowadays to get an income certificate to prove that their father or someone on whom they are financially dependent, they are earning less than rupees 8 lakhs per annum, and hence they also do not own anything of like 5 acres of agricultural land or 1000 square feet of residential place in an urban area or anything of that sort, and it's very easy. So there should be a mechanism to check. There should be a proper mechanism to hold inquiries if a one person is actually eligible to get an EWS certificate or not. That's what I'm saying. Okay. However, we have to remember that the major objective of the reservation system is to reach certain specific sections of society who are the most disadvantaged and bring them at par with others. It is logical that the EWS reservation should aim to benefit the poorest of the poor, since only economic criteria are being taken into account. Okay. See, exactly, Chitralekha Bhagwati is explaining the situation very, very rightly. She says that I am having 10 acres in Tamil Nadu, and I could be a resident of Telangana where I hide my assets of other states. That happens. You are talking about two different states people hide within while living in one state only. So there should be a mechanism to check this. Okay. Another aspect that we need to consider is whether there is an adequate representation of the class of citizens which the EWS quota seeks to benefit. There should be adequate representation. Like if I am a deserving candidate within the EWS quota, I should get the certificate and I should get a job out of this quota. Right? As per the data released by the PIB, around 52% of employees in 78 government ministries and departments belong to the general category. As per the data from All India Survey on Higher Education, around 43% of students belong to the general category. Even though data available does not specifically point out the proportion of representation of people belonging to the general category, but falling within the bracket of EWS as described, it can be safely concluded that they are not underrepresented in any way, as the overwhelming majority of the population falls in the EWS category. Not only that, data reveals that around 28% of the students enrolled in 445 institutions ranked by National Institute Ranking Framework belong to the economically backward class. Interestingly, the threshold for maximum income used for demarcation of EBC is much lower than rupees 8 lakhs. Hence, we can safely conclude that currently the class of individuals carved out by the amendment suffers from over-inclusion. Okay. Ayush is asking where is the mechanism. That's what I'm saying. There's no mechanism, Ayush. There's no mechanism to check this. I have personally seen people who were telling me that I have got an income certificate issued to prove that my father or any person on whom they were financially dependent earns less than rupees 8 lakhs, and they were able to also hide their assets. I have personally seen. There is no mechanism right now. Okay, there is no mechanism right now. Who holds the inquiry? Who goes to the place and sees what assets he possesses? No one does that. Okay. This is not foolproof. The whole process is not foolproof. Conclusion. Now, in the context of the recent controversy about the implementation of the EWS and OBC reservations in all India quota seats in the NEET PG exam, the question of the constitutionality of the newly introduced EWS quotas naturally arises. The EWS quota has been introduced through the 103rd Amendment. There are three issues that make the amendment constitutionally suspect. Now, there are three issues that which are making this constitutionally which are raising questions and question marks on the constitutionality of the amendment. First is the fact that the EWS quota would push the total reservation above the ceiling limit of 50%, makes it important to analyze whether the ceiling limit is inviolable at all. Secondly, the fact that this quota is solely taking economic criteria into consideration needs to be discussed because the notion of backwardness has generally been construed in relation to caste. Okay, first is EWS quota is pushing the constitutional ceiling limit of 50% beyond 50%. Okay, when already there is a judgment of the Supreme Court in Indra Swahani case that 50% ceiling shouldn't be violated. Okay. Secondly, the fact that this quota is solely taking economic criteria into consideration needs to be discussed because the notion of backwardness has generally been construed in relation to caste. Secondly, the constitution has not recognized economic backwardness as one of the criteria. Only the caste or the social and educational backwardness were the criteria for giving reservations. Third, the criteria set for carving out EWS seems to be over-inclusive because we are over-including people. There are already people out there in the general category who are well off, but they are still being included in the EWS because 8 lakhs per annum is a huge income for the people in the general category who are already socially and educationally well off. They are a bit economically backward, and their situation and their income limit cannot be compared to the people of the OBCs. Right? So this is over inclusive. As far as the 50% ceiling limit is concerned, it has been the result of an attempt by the judiciary to accommodate the competing principles of formal equality and substantive equality. It was introduced in the case of M.R. Balaji and reaffirmed in the case of Indra Swahani. However, in Indra Swahani, the Supreme Court did recognize that a need might arise to exceed the 50% limit in case of extraordinary circumstances. Hence, if there is a compelling need to give reservations to a disadvantaged group to bring them at par with others, then the 50% limit on reservations can be exceeded. Coming to the second issue, introducing reservations on the basis of economic criteria alone is not repugnant to the law. As per the twofold test to determine backwardness laid down by Justice Chandrachud in KC Vasant Kumar case, firstly, a class of citizens should be as backward as the SCs and STs, and secondly, should satisfy the means test set by the state government. However, the problem arises when we look at the criteria set by the amendment for demarcating EWS. Data from various sources point to the fact that not only is the criteria over-exclusive, but there is no apparent underrepresentation of the intended beneficiaries in public employment and higher education. Why SCs, STs and OBCs were given reservation? Majorly because they were underrepresented in the public services. Do you think same is the case with the people in the general category who are earning less than rupees 8 lakhs per annum? That is not the case. They don't seem to be underrepresented in the public services. There are 50% people already working in various 78 government departments and ministries who belong to the general category. There are 43% students in almost all the educational institutions together who belong to the general category. Do you think these figures point out to the fact that they are underrepresented? That is the question this article is raising. Hence, even though the introduction of the EWS quota is conceptually sound, the criteria set to demarcate the class of intended beneficiaries need to be reconsidered. Okay. Okay, so this is complete. And if you have any questions, you are most welcome to ask. बात जज्बात तो तुम is saying no questions to ask. Understood? Okay. Anyone else? Okay, then I'm signing off. Thank you all. I'm signing off, and we shall meet tomorrow with another topic. Till then, all the very best. Thank you.